Brian's going to go through some complications and some case scenarios that we've had. Take it over.
No worries. All right. So in the past, obviously, as we have been working together, we've encountered a multitude of cases that obviously has encountered some problems and problems that we could fix, and some problems from coming in to us and asking us to help them. And obviously, these are things that I have compiled just to outline a couple of issues that we noticed that partner visa refusals, or sort of issues that come with partner visas as well.
It might be a bit technical.
Yeah.
So, I mean, I guess if it does relate to you,
exactly,
message me or call me and I can talk.
Yeah,
but
exactly.
This is just to explain some situations.
So, yes. So, obviously, we've had applicants in the past, obviously, been refused a partner visa, and wish to quickly apply for another partner visa straight away, concurrently. And obviously, these applicants do not meet the so-called, I'm guessing, Schedule 1 of their visa. So, and for them, they are not actually allowed to apply for another partner visa concurrently after being refused from another partner visa. Yes.
But if you go offshore, come back on a new visa during COVID, which is not going to happen, then you could apply for it again. Let's say,
Okay. The second one in regards to the Section 48 bar case studies is that we had a client obviously been refused, or we could say refused, or had a period of time that is unlawful in Australia. They can actually apply for a partner visa if they're within sort of the 28 days of the last substantive visa of where they're refused. And also, if they meet the offshore requirements of Schedule 3, which is for compelling and compassionate grounds.
Right. Yep, that's correct.
Okay. And obviously, they still have to meet the first schedule, which is a visa application.
Yeah. So the problem here is that a lot of people, you can't read that on the immigration website.
Exactly.
But if you guys are good enough and know where to look, you can look in the Migration Acts and Regulations. It is there.
Yeah.
But there are some rules on how you can be eligible for a partner visa.
So I think for the second part, in terms of people who have been refused and unlawful, I think obviously we've encountered clients in genuine relationships in the past.
Yeah.
We once had a lady that was unlawful for quite a number of years as well.
5 years.
Yeah. And obviously she was in a genuine relationship with her, her partner who is Australian, and they had a kid together. So obviously she could apply for her partner visa on the compelling and passionate grounds, I believe. And then she was been granted her partner visa eventually, and then gone from there.
I think another thing I need to say though is that you got to realize that this is compelling and compassionate grounds on the grounds, and it's made on the time of decision. So, I don't want to go overseas, I've got a child, makes sense.
Yeah.
But then you can imagine a lot of people calling me, telling me, I'm illegal, it's COVID, right? And I can't go out and come back. So at the point of time of application, yeah, cool. But then let's just say COVID disappears in 2 years' time. At the time of decision, you're still relying on COVID of the reason why I didn't make an application offshore. So that's why there's a lot of people telling you can do it.
Yeah.
Because they haven't made a decision yet.
Yeah.
Right?
Of course.
But you got to realize that legislation says at the time of decision, there is compelling and compassionate grounds why you could not return to your country. Okay.
So I believe the grounds you want has to be something that is very circumstantial to that person.
Yeah.
Okay.
Yeah.
Okay. Where's my mouse? I lost my mouse. There we go. All right. The second case studies we'll talk about is obviously the PIC 4020 issues. We deal with multitudes of visa applications from ranging from students, working holiday visas, tourist visas, all the way to partners and other visas. So generally speaking, most partner visas are on the back of students onshore. Tourist visas coming in, visiting their partners, working holiday visas, working visas or whatnot. So what happens is obviously in regards to PIC 4020 is more about, providing false and misleading information on a immigration document or card on your application as well. Okay. So we have had clients in the past, obviously, whom had a student visa or a tourist visa, and they've come in and did not inform immigration on the visa application that they were in a relationship, subsequently applied for a partner visa, I believe, and then obviously were refused because they didn't meet the PIC 40.
Yeah, so what happens here is that I can imagine there might be some of you guys on student visas, and you might have been advised by your agent that don't say that you're in a de facto relationship because your visa will get refused on genuine temporary entry, right? So people put themselves as single, and then a couple of months later, you put in a partner visa on de facto.
Yeah.
They go, well, in the last 12 months, you said this. So you got to be very careful on how you answer on applications.
Yeah. Personal particulars forms, Form 80. Some people have completed these in the past and sort of did not outline certain things like character. If you've committed a crime in the past or you were affiliated with any of the character sort of list requirements, there's a sort of list on every visa. Form 80 that outlines, have you ever dealt in, narcotics? Is there, crimes in the past you committed? Are you a war criminal? All these different questions they will ask. And if you ticked no, but you actually fit into one of the criteria, you can also be done for PIC 4020.
Another one would be, there's a little question, like there's a million questions, and there's one question that goes,
have you been refused?
Have you been refused a visa, right? And you might have been refused something ages ago and you forgot.
Yes.
Another one I think is a very loose term. Are you associated with any known criminals? And you might have a friend that's in jail and you visited them, right? You got to be careful on how you answer these. You better off answer it truthfully. It's easy to deal with, because if you aren't, then it's very hard because you've lied on the application.
Yeah. So even obviously family members or whatnot, if they have committed crimes in the past, maybe it's best to disclose this on these forms. The easiest one that people always have a tendency to provide false information is your incoming passenger card, which obviously everyone provides when they fly to Australia. Some people obviously put in there that they are in a single relationship. They don't have a partner. They don't write a contact detail for the person they're visiting, and all these things can be picked up by the department and used against you at a later date.
But the most important one is there's that one part that asks, have you got any criminal convictions? Again,
exactly. Yeah.
And people take no. And we're in a law firm. I deal with this every day. I've got people getting cancelled every day because they have a traffic offence and they thought that's not a criminal conviction.
Yeah.
So every day I'm dealing with things where people didn't disclose criminal convictions. I had one guy that's been accused of lying to the department 18 times. That's because he flew in and out 18 times.
And he didn't.
And he never declared.
The character grounds.
The character grounds. And do understand, this also includes when they ask you about your declarations of things such as, wood, food, stuff like that. Yeah. If they want to be really mean with you, they can do that as well.
Yeah. Okay, false claims of working holiday visas or work and holiday visas, right? So obviously we've had clients in the past go from working holiday visas to partner visas. We've encountered problems in regards to a few different categories. One of them obviously is that the working holiday requirements, they did not meet. One, obviously the work requirements to work in rural, to work, in the respective regional postcodes. In the past, they have obviously failed to disclose to immigration that they didn't do it. They've actually some of them decided to actually pay for it. And, and obviously once they apply for their partner visa, everything gets pulled back in, and then obviously gets, all these conditions get dragged up into it.
Correct.
What's another one that you can think of?
People changing their ID by coming on a new working holiday visa with a different name, different birth date.
Yeah.
It will backfire.
Yeah.
It will backfire. So just be very careful. I know some people have done it. Just be very careful with that.
I think we've encountered someone that's actually gone and finished the first working holiday visa, left, changed one word on their name, and
not even finished the first one. Finished the first one. Second one went out,
came back in, and on the new one, and tried to do it again, and she
got it. She got it though.
Yeah.
She got the working holiday visa.
But then
she got the second working holiday visa, and then she did the partner visa. And one thing you guys have to understand, like what Brian's written on the bottom, this will follow right through to when you get your citizenship. Like the guy with the 18 times that he lied. Yeah. It will be there forever. So just be careful.
So obviously we look at things like, obviously we've had clients in the past as well, that have done protection visas, which were false and unsubstantiated, and then come to us and say, hey, I want to apply for a partner visa.
Yeah.
And so these circumstances, we obviously had to, let them know that, your partner visa, your protection visa application is going to follow you into your partner visa application. What did you tell them on that protection visa? Was it real, or was the claim real, false, unsubstantiated? If it is, you can be done for PIC 4020 as well.
Yeah.
Yeah.
I think we're going back to the character grounds. Just be careful. Traffic offences are considered. Drink driving is something that you can be refused on. A lot of people have assault charges, for instance. But that's just not just the applicant. This goes to the sponsor as well. If because of domestic violence, if there's a prone to violence for your sponsor may, most likely, will be ineligible to actually sponsor you because there's a domestic violence provision, which Brian will go through afterwards. Essentially, if there is any domestic violence during the application, the applicant can still get the permanent residency and not be in a relationship with the sponsor.
Okay. Yeah. Obviously, the middle one, the one I forgot to say, I kind of jumped two down. I apologize. I think I went from a thing. Yeah. So we obviously have to talk about previous relationship declarations, and any form in mind you can ever think of that goes to the Department of Immigration, you always have to disclose your relationship.
Yep.
Because if you don't, immigration will dig it up and one day and obviously use it against you. And this, as I wrote in the bottom, is a 3-year ban, which can apply to applicants who fail to disclose this information above. And this can follow you all the way until citizenship. Okay. All right. I think for the last complication today, we'll talk about family violence. Family violence, obviously, in Australia has been quite a big issue, I believe. I think it's been in the news over the last year or two in terms of family violence. This little snippet below is an outline from what Department of Immigration views as family violence. They look at obviously physical violence, sexual violence, verbal, emotional abuse, controlling behavior, stalking, technology facilitated abuse. Yep. Financial abuse of the elderly, and also forced isolation and economic deprivation. This includes dowry related abuse. Okay. We're going to go through obviously the general cases. Obviously, we've done a few of these cases in the past. I think we've done more than a few actually. And obviously, applicants, come to us. They want to, they come into our office and they say, Anthony, I'm looking to, I need to know what is happening. Like I'm being abused by my husband or wife. You know what I mean? And I feel that I should be applying or trying to apply for the domestic violence, family violence clause. And so we have to look at it in a very, in a very broad perspective.
Yeah, because a lot of people don't realize that they're in an abusive relationship. Either it's culturally or being stubborn. I'm not going to share cases because I don't think it's very appropriate of the ones that we've dealt with for privacy of these clients. But there's been, things from assault, emotional abuse, sexual assault, financial abuse, so, people stay in a relationship because they want that 2-year period, like I said. But you got to understand that, there are options for you. But a lot of people, they don't understand the culture of the Australian culture, and they might think a swear word, for instance, is abuse. And they come in here and they tell us, hey, Anthony, I've been in a domestic violence. And I was like, what happened? So he said the swear word to me. Like, well, okay, this is going to be very challenging.
Yeah, right? Because obviously we will need to prove how emotional abuse arrived from that swear word. Correct. Which is sort of something that obviously as sort of working in our end of the spectrum, we won't be able to prove, but we will need obviously our clients to go out and get that evidence from, psychologists, social workers and
correct.
whatnot.
So you got to understand it's not, cultural aspects where things could be a cultural nature where your culture doesn't accept it. You got to understand, you got to run the definition of what's family violence with immigration.
Okay. So in theory, a lot of people, when they do the family violence claim, they'll encounter a couple problems, obviously, that arise. Is that one, they will stop collecting evidence on their relationship from the time they applied for the temporary visa and from the time when family violence has occurred. They, because a lot of people don't understand that they are still meant to be collecting evidence from.
That's a good one. You know how I was mentioning that it's 2 years from the time of lodgement. People get very excited when they lodge the visa and then they forget to collect data. And then after 2 years, I tell you to give me some more evidence for your permanent residency. By then you probably have kids or bought a house, a full-time job. So it's very important regardless to always collect the box and put all your things in there, for safekeeping. So then it's easier.
And this also still applies for family violence, because obviously immigration will ask you to provide evidence that you guys were in a genuine and continuing relationship for that period of time. Okay, so that's one issue that a lot of our clients face as well, because obviously after the family violence has occurred, there is a tendency for obviously placement. A lot of them aren't living in the same house, they're not living together anymore. So a lot of this evidence should be kept, with the applicant at all times.
I guess a lot of people that are experiencing domestic violence and they don't know that they are, they aren't obviously taking any more evidence that the relationship has continued, and then we'll have to go to the tribunal and argue to the tribunal that the relationship was genuine right until the time of the abuse, and that you left because of the abuse. If people stay, you just broke up and you're being annoying and you're causing trouble and you're trying to claim that's an exclusive relationship still, then it doesn't work your way. So if you do experience domestic violence, walk. Demonstrate at that time 100%. it was real. So a lot of people hear about it. They hear from their friends, "Oh, don't worry, it's okay. This happens. You're gonna be okay." You just need to be careful on how you handle your situation.
And lastly, the second thing that immigration would like to also look into is the sort of the evidence behind domestic violence. All right. Obviously, they look at two different types. So one is obviously the judicial evidence. That's more in relation to the decisions by the courts or any criminal convictions of the sponsor. All right. And the non-judiciary evidence, which is the joint undertaking, which is also decided by the court, but it's not a sort of judiciary evidence used. The Form 1410 should actually be completed by the applicant and provided. It's a fundamental statutory declaration. And lastly, third-party evidence, which is actually the most important one.
But at the end of the day, we presume that this would never ever happen. But we do have an obligation and duty of care to acknowledge this.
Of course, 100%.
And we advise this on every consult so people know, because some sponsors can be abusive. Some sponsors would tell you, if you don't do this, I'm going to report you to immigration.
Of course, controlling behavior is part of the list.
So we don't want you to feel that this is going to happen. We don't encourage this at all. But we're just trying to inform you. That's it. All
right.